Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Episode 60, Open Source Toyotas.
This Week in Law is brought to you by Audible. For your free audiobook, visit audiblepodcasts.com/TWiL.
Hi, this is Denise Howell, and you're tuned into This Week in Law, Episode 60. I feel like a bit of a game show host this week because we have two returning contestants from last week, Marty Schwimmer. Welcome back to the show.
Hi, Denise.
Hey, Marty, great to have you back. And also Kevin Thompson. Kevin,
hey,
great
Denise.
to see you.
Nice to see you too.
And our newcomer this week is Xeni Jardin, first-time Twiller, but not first time on the TWiT network.
Hey.
So great that you could join us on TWiL.
Hey, Denise, great to be here. I hope I win the new car.
I hope so, too. And I hope that we don't have any live action earthquake coverage during this particular show. Because if we do, you and I are both going to be the guinea pigs here, being down in SoCal. So really fun to have you with us. And Xeni, of course, writes and does a wonderful video for boingboing.net. Kevin writes at cyberlawcentral.com. And Marty, of course, is the trademark lawyer at the Trademark blog. As we were saying, Shakespeare loves our blogs, Marty. What was it? Yours it was a product of A Winter's Tale?
I think you have to set it up. Question for you, Denise, is why is your blog called Bag and Baggage?
Yes, and it was some obscure line from Shakespeare I found that sort of meant kit and caboodle, the whole shebang. And yours from The Tempest, Oh Brave New World, that has a trademark blog in it. So thrilled.
At least my copy says that.
Yes, exactly. So we'll get to some trademark-specific issues in a bit here on the show. But I wanted to segue from some earlier programming I was watching on the TWiT live stream before the show. They had this week's Mac Break Weekly running in rerun. And one of the topics that came up there was the new Google Editions service that we can expect out later this summer, which is going to be Google's entry into the ebook store arena. And I just wanted to toss this out there. We don't know too much about it. It was mentioned briefly by a Google representative at a conference in the book industry. But I wanted to get your guys' quick take on what we know so far about Google Editions and how you think this changes or is poised to change the marketplace. What the unique thing about the new service is apparently it's going to have a huge number of titles. There was a report from Japan Today that says combined with all of its deals with publishers and its large catalog from its own book search service, it's poised to have over 4 million titles. And it's also not supposed to be device-centric, so that unlike the ebook store on the Apple iPad, or to some extent the Amazon Kindle store, which works primarily on the Kindle but seems to work quite well in applications for limited other devices too. This one is going to be designed from the ground up to work on whatever platform you want to be reading on. So Xeni, why don't we start with you? Do you think this is a revolutionary development? Are you looking forward to it?
You know, I think as many viable points of competition that can exist in this particular space are good for consumers, they're good for book publishers, and they're good for writers as well. People like all of us at Boing Boing who either have books out or have them in development. One question that I'll be interested in seeing is whether or not Apple decides to play nice with this new service.
And how do you see that unfolding potentially?
I mean, I don't know much about the technical details of exactly how the books will be delivered, whether this is something that requires, an iPad app, or whether this is something that is completely browser-based. But the Kindle doesn't seem to be the dominant or leading device for very much longer. The iPad, I'm imagining, is really going to take the lead there. I think it's great for consumers that there's interoperability between Kindle titles and the iPad device, even if the reverse is not true. And whether or not this service is usable on multiple platforms that people are already comfortable with, just device platforms, will be an interesting issue to watch unfold.
Right. Marty, what do you think about the Google entry into the e-publication business?
Well, first off, I want to agree with what Xeni just said. As someone who has the Kindle on my Metro North commute every morning, and I find myself looking longingly at the people who have iPads rather, I agree. I think the Kindle's time has come unless they're able to reinvent it as a more open device. As to any kind of intellectual property aspect to it, I think we may be seeing proof of Professor Lessig's point, which is that there's a whole lot of stuff in the public domain or underexploited copyrightable material that we are finally going to get our hands on thanks to initiatives like this one.
Yes, that's something I've been noticing on the iPad, that from the get-go, the e-book store there, the iBook store there, really featured and made available not an incredibly wide range of public domain material, but enough that you really get a good idea of how this is something that can have a new life on new reading devices. Kevin, what do you think of all this?
Well, I think it's great that there are a lot of more ways to get the public domain stuff out there. A lot of the things that are on the Kindle and on the iBook store that are in the public domain have been available for years in other these formats. And I think it's great that they are letting people know that they're there. Is for some of the other copyright aspects of it. I think as long as you get the proper permissions and putting it out on the proper device, I think you're in good shape. I'm a little bit concerned about the DRM that might be on certain books. For example, the iBook store has got, my understanding, proprietary DRM for certain titles, but still will allow, I think, books in the EPUB format to be inputted on there.
Yep, I just put one on this morning. Cory Doctorow's new novel, FTW.
Ah, yes. Yes, I have that on my Kindle for the Mac app. It's quite cool. I'm looking forward to getting through that. Enjoyed Big Brother. Little Brother, too. I mean. It's a great book.
So, yeah, I mean, it is nice how Apple has decided to embrace a format that both supports DRM for those publishers who insist upon it and enables a completely open. As I understand it, the EPUB format can be totally DRM free. I'm not 100% sure on that. But,
my understanding is yes, it is DRM free. I've got an EPUB reader for my Mac, and I've got one on my little Windows mobile device. So it, certainly it can be DRM free if that's what's required.
Right. So it seems like this creates potentially a great world where you have an enormous volume of titles available from one source, and it can both sort of give new life to Project Gutenberg, which I'm sure people have enjoyed for many years on the web, and others like it that are, aggregating and formatting public domain works, and marrying that to devices that actually make them pleasant to read and have with you, and the whole Borders Amazon bookstore experience that the commercial publishing world still demands. Xeni, what were you going to add?
Yeah, Yeah, I was just going to say, as someone who thinks of herself as more of a visual person than a text person, I'm excited about what this means in terms of authors, creators, being able to create visually and media-dense digital books. Part of the reason that I feel like I personally have migrated away from reading a lot of books in text over the past few years is that I just feel like I'm so spoiled by the richness of available image stimulation. You know, there's video, there's photo, there's kind of constant activity for your eyes on the web. And as someone who, is just now accustomed to that, the question of what digital books can be is something where, you're sort of going through the text, you click on a link, and you can listen to the sounds of the birds and the trees that the person heard when they were on a safari in Africa. Or you can click into the image of the face of a character, or see video of a historical event. Maybe you're reading a historical novel and you want to look at Hitler in the bunker. Just the idea that you can blur the boundaries between these different mediums. I feel like the more platforms we have in the marketplace, the more innovation can happen on that kind of aesthetic and experience level.
Yeah, I totally agree with you. And I think the stuff you guys do at Boing Boing is a perfect candidate for packaging up in some kind of fantastical way for devices other than web browsers.
Yeah, I mean, I was just at a conference this week where I was asked, will the web as a source for information from Boing Boing or other blogs, will the web as a platform ever be obsolete? I don't know that the internet will, but the idea of going to a website like Boing Boing to get your daily fix of all the weird stuff that we do, I wouldn't mind if that became obsolete, and if we were delivered through lots of different platforms, maybe some that are really thin and fast and shallow for mobile devices, and others that are richer and feel more like books. We built an iPad edition in time with the iPad launch that sort of hints at that, but we're all kind of chomping at the bit to see where that can go in something that feels more like a book, more like a living digital book.
Mm-hmm. Well, we look forward to that. We'll definitely stay tuned. Something that is a book not in the public domain is Catcher in the Rye. And it has been the subject of some interesting litigation and developments in Marty's neck of the woods. Marty, why don't you tell us a bit about this case and how the injunction ruling unfolded there?
Well, I have a writing assignment for you and your audience. I want you to take a fictional character whom you disagree with. You don't like their ethos. You don't like what they stand for. And I want you to write a short novel in which you comment and critique that fictional character to make your point. Just as a short background, what happened was, of course, Catcher in the Rye, one of the more successful books that everyone is forced to read in high school. And its author, Salinger, died about 5 months ago. This lawsuit began during the last few months of his life. What had occurred was a young author wrote a book called 60 Years After, in which he reimagined the protagonist, Holden Caulfield, 60 years later, and he encounters the author, Salinger, who was by this point a recluse in New Hampshire, and he meets his sister Phoebe again and has some of analogous adventures to those in the original book. So the Salinger and then his estate sued for copyright infringement. And at the district court, it was held to be an infringement, that it was not an acceptable parody. It borrowed from the original, and unfortunately for the author, any kind of argument that this was purely a critical work, a critical parody, seemed to be post hoc, and here was an important fact. Before the book's publication, it was advertised as a sequel. And I think that was very important in dooming their case. The lower court enjoined the publication. And this is what's interesting about this case from a legal point of view, is the Second Circuit decision, the appellate decision that came out about 10 days ago, has made it a lot harder to get a copyright injunction in the Second Circuit, which, along with the Ninth Circuit in California, has a majority of the cases relating to intellectual property as far as the entertainment and communications industry is concerned.
And we should explain just for someone who's not familiar with the term or the process, that an injunction is a decision by the court early on in a case that somebody's business or operations or whatever activity they are engaging in that is at issue in the case and alleged to be unlawful or infringing or what have you.
Right, a preliminary injunction.
Right. It can be put to a stop pending the litigation if you make a strong enough showing in the court that the court thinks you're likely to prevail at trial. So the Second Circuit in this case has actually taken that standard, well, suggested that perhaps the court should have looked more closely at how that was going to be applied. Is that right?
Well, specifically, the old test was pretty much only asking, will the plaintiff likely prevail at trial? And if the answer to that was yes, then they would make one more presumption. If they're likely to prevail on their copyright claim, then it is probable that they are being harmed in an irreparable way. The mere act, the continuing distribution of the infringing work will harm them in a way that money cannot solve. So that those two questions, which they, in a lazy way, only answered the first one, used to be the old test. And now it's a four-part test. Are they likely to prevail? Is the harm to the plaintiff irreparable? What is the harm to the defendant? And also, is there any public interest involved? Can we think of a situation where an injunction of defendant's product, even if infringing, might harm the public in some significant way? There are not a whole lot of cases on this. I can think of some edge cases, like perhaps a life-saving drug that's affordable. Maybe you would make a public interest argument. And as a result of applying the wrong test, the Second Circuit vacated the injunction. They did not say that the defendant was likely to win on any of these points. They merely said to the lower court, you didn't do the right test, go back and do the right test. And by the way, we think that the defendant is still going to lose. So from a legal point of view, copyright injunctions, preliminary injunctions, are going to be harder, more expensive, more difficult, because there's just four times as many points that you need to prove. But the reason why I was nagging Denise to discuss this, I just think from a cultural point of view, it's sort of hard to have this form of expression. So I could count on one hand the number of works where someone really reinvents someone else's character, and most of those involve public domain characters. Some of you in high school may have read Tom Stoppard's play Rosencrantz and Guildenstern Are Dead, where Tom Stoppard took two minor characters from Hamlet and made them the protagonists. The movie for several years ago, and based on a graphic novel, League of Extraordinary Gentlemen, that reimagines public domain characters.
Right. They're fictional mashups.
I knew you'd bring that up. I'm not really talking about fan fiction, which is obviously, I'm sure we're going to talk about this. But yes, they're fictional mashups, but they usually involve to the extent that they're any kind of widely distributed work. They tend to be based on public domain characters. So this sort of 60 Years After book is quite unusual because authors like Salinger tend to sue.
So in this particular case, it's going to go back to the trial court, and the trial court's going to have to decide under this four-part test, yada, yada, if an injunction should issue, and then ultimately whether the work is authorized or it's infringing and has to go away entirely. You mentioned a public interest factor. Couldn't free speech and creativity and fair use satisfy that kind of a consideration?
I recommend reading the public interest discussion of of the decision. They do talk about whether public interest can be served. Last week on the show, we talked about a veiled reference to Scientology tracts being made public. I think that sort of situation could be the sort of fact pattern where there's a public interest in allowing the continued distribution of the work, even if held to be infringing. There's not as much as an obvious public interest in allowing, a infringing novel to be released. By the way, I should point out one successful case, neglected, and that was The Win, Done, Gone. About 8 years ago, someone reimagined Gone with the Wind, told from the perspective of the African Americans in that book. And that is a situation where the Margaret Mitchell estate had prevailed at the district court, but the 11th Circuit said this is acceptable parody commentary on the copyrighted work. And there was ultimately a settlement. But essentially, that is an example of how to do it. The win, done, gone.
Mm-hmm.
Right, I was going to bring that up. And I also have been thinking, as we've been having this discussion, of works that I often see featured on Xeni's site, Boing Boing, things like Pride and Prejudice and zombies and basically anything and zombies.
You could probably just go back, particularly through Corey's archives. He's got a great knack for picking up crafty and clever and very readable reinterpretations or parodies.
Right. So I'm assuming that many of those have adopted public domain works as their basis to inject zombiedom.
The smart ones certainly have.
But that some have not. And I'm wondering, I haven't really seen any legal discussion around those works. I'm wondering if Marty or Kevin or Xeni, you guys have.
Well, usually sorry, Marty, go ahead, please.
No, I was going to say, in preparation for this, I had a hard time finding situations other than The Win, Done, Gone where someone was successful in taking a copyrighted work. The zombie work, Jane Austen, was the early 1800s, so
Right.
Sure, it's going to be public domain.
Mm-hmm.
I was just going to say, usually when we hear about them, it's too late, and you have someone with who didn't ask for any legal advice ahead of time, asking for help after they get the lawyergram, and we're not lawyers.
Kevin, fan fiction is one of your pet interests. Do you have anything you want to add to the discussion here?
Well, I think fan fiction is a little different, only in the sense that it depends on the particular work that's the subject is about. There are certain copyright holders that are very fan fiction friendly. I can think of Paramount and the Star Trek franchise. They're certainly very friendly to it as long as you're not doing it for commercial gain. They're fine with it. There are others, though, that are much more restrictive. And then you take the chance that you do it prominently enough, you're going to raise the ire of the copyright holder. In terms of some of the public interest in having these common genres out there and available for discussion. I mean, a lot of people are familiar with the characters from Lost from watching the TV show. Should the people be able to use those characters then and use them in other ways for more of a general discussion of other issues, and yet still be recognizable as the characters from Lost? That certainly is going to be a problem for the people that would write such a work. But whether we have an interest as a public in doing that, I think that's a bigger discussion. The way our copyright laws are written, they provide such sweeping rights to the copyright holder that if they are not happy with it, they certainly can shut it down. Now, again, you get into some of a discussion of whether or not it becomes economically feasible for them to do so. They certainly wouldn't necessarily shut down, fanfiction.net and some of the others where they're certainly making a non-profit use of the particular works. But some of these sites, develop their revenue from advertising. And so the more advertising they get, the more money they make, and the more likely that they, would run into an unhappy plaintiff.
Right, and the plaintiff here is unhappy based on their economic decision, I guess is what I'm trying to drive at. The law would entitle, under most instances, a suit where there's appropriation of a copyrighted character, trademarks, that kind of thing. So you're saying that folks make an economic decision and strategic decisions about whether they're going to go ahead and enforce our broad copyright laws.
I'd say that's correct.
The other thing that, I guess we should point out the difference between something like what you're describing, where someone might make a work out of Jack and Sawyer and Kate from Lost, say, and have them have their own adventures, and what Jimmy Fallon has done on his show, which is create a whole mini series, show within the show. I think it's called The Floor, where they have a bunch of folks trapped on a floor in their building that is sort of loosely based on Lost, and I think more trending toward the parody. There aren't any duplications of the name of the show or the actual characters. It's more of an homage to the funny aspects of the show.
Yeah, I thought Xeni made a good point. The fact that a lot of the times the authors are coming to the lawyers too late. They've only after they've received the cease and desist letter. They didn't come to the point of beforehand. It's should I be doing this? At that point, we could provide a better guidance on some of the fair use factors. I can think of the Dr. Seuss case with the O.J. Simpson parody, where they lost because they weren't parodying Dr. Seuss, which was the actual copyrighted work. They were trying to make fun of O.J. Simpson as opposed to Dr. Seuss.
Well, wouldn't somebody be able to make fun of O.J. Simpson?
Well, certainly they can, but they didn't necessarily need a copyrighted work to do so.
Oh, I see. So they put him in the context of another copyrighted work, and weren't parodying it, but him.
Yeah, the work was called "The Cat Not in the Hat."
Aha! Yes, I hadn't stumbled across that before. We'll have to check it out.
Yeah,
if it's still available anywhere.
I doubt the actual work itself. It's probably quoted in the opinion, if I recall correctly.
All righty. Well, what I'd like to do during the show at some point is give people a resource of the week and a tip of the week. Since I have a resource on this topic, I'll go ahead and give you that one now. And it is, we've talked about chillingeffects.org before on the show. They have a whole fan fiction section at chillingeffects.org/fanfic that answers all your questions about copyright and trademark and how you can try your best to navigate the legal considerations around fan fiction and get yours out there without getting yourself sued. So if that is a passion of yours, do check out chillingeffects.org/fanfic and get yourself out of the context where we're hearing about it after the fact when you get sued. So I did want to go around and see if anybody else has a resource of the week. Now would be a nice time to share it. Marty, did you have anything that you've been using or considering?
Well, clearly for any kind of issue relating to copyright and trademark law, the most important resource is trademarkblog.com. But having said that, Justia, JUSTIA.com. All papers and decisions in any federal court have been made on, or most of them have been put online thanks to the PACER system, which is operated by the government. Justia is a full-text search on top of PACER filings. So if you want to know, has somebody ever sued or been sued, or you heard about a case, you can look it up for free and get many of the important documents in that case. Justia.com.
Great. And Xeni, any resources you want to share with our viewers and listeners? Oop, are you on mute, Jenny?
This always happens when I go on one of the TWiL network shows.
Okay, it happens once a show to all the shows, I think.
Exactly. So far, no earthquakes, though, so that's good. We do recommend that people take a look at chillingeffects.org, and I check EFF.org every day for the latest news.
Absolutely. And Kevin, how about you?
Well, I was actually thinking about Chilling Effects of myself as a resource. The only thing that immediately came to mind as an alternative is the EFF has some great resources on legal guide for bloggers that certainly shows it's bears repeating. I don't know if you folks have pointed out in recent shows or not. I know you have in the past, but I think it's been a while.
Yeah, it's certainly always worth reminding people that it's out there and reminding folks that it applies beyond just the world of blogs. Whenever you're having activities online, it's a good thing to check out.
I'd agree with that. I think the discussion is certainly very general on these topics and provides good advice.
Right. And since we've been talking so much about chilling effects, that's actually a nice segue to our next news story I wanted to get to, which is Supreme Court nominee Elena Kagan, who, among other things, was quite active in the Berkman Center at Harvard, which is one of the partners in chilling effects, and actually was instrumental in getting Professor Lessig to come on over to Harvard and lend his energies there. So folks have been speculating, particularly Eric Gardner, the Hollywood Reporter Esquire, who's been a former guest on our show, has a piece up about how he thinks that potential Justice Kagan will be quite friendly to the world of fair use and more sort of copyleft considerations. Now, there's a counterpoint piece in The Atlantic that basically says you can make all the speculation you want on that front, but we really don't know enough about her. And if you want to speculate, well, here's some net neutrality information that tends to say that she would be anti the FCC's recent efforts along those lines. So it's hard to say, as always, how a Supreme Court justice will rule once he or she is sitting on the bench, but it's also fun to sort of play the game of guessing from their background. Kevin, have you taken a look at this, and what do you think of potential Justice Kagan?
Well, I think I agree with the analysis that it is her resume is much more of a blank slate. It's real hard to say for sure what some of things were her own personal opinions, versus her directive as counsel when she was for example writing the brief with the Supreme Court asking them not to intervene in the DVR case.
Could you explain that a little further for folks so they know exactly what she did there?
I'm trying to remember the exact details of the underlying dispute, but it has to do with the Cablevision. They have a DVR system that was alleged to infringe the patent that was held. I
think the critical question in that case had to do with place shifting more than anything else.
Right.
Remote storage, whether it could be, whether materials could be called up only locally from a user's DVR box, or whether they could call out to a remote location and bring them into the home. And there was a lot of consternation on that front. And as Solicitor General, Ms. Kagan here wrote a brief urging the court to go ahead and embrace the place shifting paradigm, and that this would not violate copyright and would be, I haven't read her brief, but what Eric Gardner has said here is that she trumpeted fair use in it. So that's part of what he's hanging his hat on, to think that she'll be a fair use friendly justice.
And I think that's part of my point is we don't know for sure how much was her opinion and how much was, directive as counsel, whether she was directed to write the brief in that particular fashion.
Right. It's interesting that we talked a couple of weeks ago, I think, about Judge Sidney Thomas, who is the Ninth Circuit judge who wrote the decision in the Grokster case that was overturned by the Supreme Court that would have let Grokster stay in business, that went ahead and said that they couldn't be responsible for the infringements of their users. So he did not get the nod as nominee, but Ms. Kagan here did. So we'll just have to see what happens with her. Xeni, any thoughts about our new Supreme Court nominee? Oh, you're on mute.
Sorry, I'm trying to save you guys from some background noise that's happening in the studio. She is an enigma, and I will be interested to see what happens, but I do have some concerns either way. I suppose one thing that I've been following online is that people are concerned that that they remain free to make parodies of her.
Right.
And I'll just leave it at that, to be polite.
Well, she is a public figure, and goodness knows her life is about to get a lot more public. So wish her all the best with that. I certainly wouldn't want to be in her shoes.
Yeah.
Yeah. So let's see. Let's check in with the world of Second Life, which I haven't heard about for years and years. Xeni, does anybody play Second Life anymore? You as our cultural touchstone here. Is anybody in there?
You know, I was just at this event earlier this week with a number of social researchers and young people, and we were asking some of the teens present, have you ever played Second Life? Have you ever blogged? Have you ever built a website? And a number of the teens just looked in disbelief. They didn't know even what Second Life was. I think this is something that people who I really identify as technology savvy in their 30s and 40s think that young people are into. And I think that that's largely a figment of imagination. I stopped being interested in it years ago.
Yes, as I said, I haven't seen it pop up on the radar in quite some time. They did have some litigation a few years ago that seems to have had a stepchild come up now. There's a class action lawsuit pending about Linden Labs' terms of service and the fact that way back in the beginning when it first launched, and there was a lot of interest in it, and they were attempting to raise money and attract users. The terms of service were quite interesting and novel in that they allowed, they had language that tended to convince people that the artifacts they were creating and buying in this virtual world were their own. And in fact, this was something that you know, if you go through and read the complaint, there are all kinds of examples about company representatives touting that as a great feature of the virtual world in Second Life. How, you know, we're just creating something that's just like the real world. You can come in, you can have property, you can have intellectual property that will be your own. And further down the road, in connection at first with this litigation they were in with one user about that sort of an issue, the terms began to change, and now they are much more in line with what we would expect from a web service provider. That, gee, you know, you have a license to use our intellectual property, and we have a license to things that you create in the world. And this idea that you own your own stuff in Second Life seems to have gone by the wayside. And a group of users has gotten together and decided that that's not okay under various California consumer protection laws, which tend to be quite broad in favor of consumers. So this was just filed and sort of brings a second life to Second Life, and we'll just have to see whether it creates some interesting law about representations in terms of use and property ownership in virtual worlds. Kevin, have you been following this in your role as a cyber law guru?
I certainly have been interested in this particular case, but I agree with everybody else that, you know, Second Life itself is becoming more passé. It used to be, when it first came out, everybody was interested in how they could exploit it. I even seem to recall there were certain law firms that were opening offices in Second Life, so they could go out and reach forth and discuss things with their clients there. But it certainly has passed down to becoming a less of a place to be. It's less of a destination than it always has been.
Right. So the upshot is perhaps they're pursuing a company in a class action that I'm not going to suggest they're judgment proof, but maybe the ability to get a large judgment against them doesn't mean as much as it did a few years back. May
not mean as much as it used to, but it would probably mean something, at least for the lawyers that are bringing the case.
Exactly. Marty, what do you think about this whole notion of the shift in terms of service?
I read the complaint, and it is clear that Linden Labs did say you own copyright in the things that you create within Second Life, and whether they have reneged on that and are now violating rights in copyrightable creations is or is not true, and that's something for the case to bear out. I found myself a little bit annoyed in the way in which the complaint read, in that they keep on saying, you told us that we own land. You told us that you own land. You have broken your promise that you own land, that we own land. And my feeling was, guys, your lawsuit seems to be based on your right to take literally an expression that is impossible. You cannot own land on a computer. You can lease space on a server. You can have all sorts of code that's stored with them, but you simply cannot own land. It's a metaphor, guys. Don't bring a lawsuit because you can't take a metaphor literally. So I was very skeptical about reading this complaint.
So sticking on the topic of games here, another lawsuit that has just been initiated is by Nintendo, and we have a press release from them in the show notes. They certainly haven't suggested that any of their users own anything within their worlds. And in fact, what they're suing over is infringement of their games by illegal copies and violation of the DMCA. And what strikes me as interesting about this is the fact that I think the root of this lawsuit and the root of their piracy problem, they seem to be casting it as, people want to get free access to our copyrighted works. And of course, there's that aspect to it. But what they go ahead and admit, even in their own press release here, is that a lot of these works simply enable the games themselves to work on their various different devices. So, we're a Nintendo family over here in my house. We have the Wii, we have the DS. But if you want a copy of a certain game, you've got to buy both versions. It is not like some of the other devices we've been discussing today, where you buy something for one platform and it works on all your various devices that it's supposed to work on. So I throw that out as food for thought here for our panel. Xeni, do you think that Nintendo is a victim of its own silly business strategy, that it's charging people multiple times for basically the same work?
Well, it certainly is going to be perceived that way by a lot of their customer base. I'd be interested to hear what some of the other lawyers on this roundtable think about the legal merits of the case. But I think, more and more as people are shifting to purchasing their entertainment digitally, this is a sensitive issue that people perceive that it's too easy for these companies to double dip and then to penalize users for wanting to share or to move content from one device to another. It's a really hot, sensitive topic.
Right. Marty, what do you think about the piracy question here? From a legal standpoint, it's pretty open and shut, isn't it?
I don't know. I think I should recuse myself because we are a Nintendo family here as well, and I think I have spent upwards to $250,000 on one game alone for each platform.
Right.
I can see defendant making arguments that this is analogous to, burning your CD so that you could play it. I mean, we have this transitory copy doctrine that you make a copy that's unauthorized, that's copyright infringement. But then you have home archival and place shifting and device shifting cases that say you should be allowed to do that. The chips, my understanding is that the chips allow you to do something more than merely just shift a game from the DS to the DSi or what have you. It will be, I think this is going to be one of those cases that turn on the precise way that the chip works.
Okay.
Yeah.
Well, going back to a situation much like the Second Life one where the users have gotten up in arms and decided they're going to take the law into their own hands as opposed to being sued for making unlicensed copies. The users of the PS3 game system have initiated their own class action lawsuit against Sony in light of a new firmware upgrade, quote-unquote upgrade, that has actually disabled various features that let users run GNU Linux and other operating systems on the console. So here we see sort of a shift in the balance of the users actually coming in and saying, hey, in the Second Life case, it was you told us something and then changed your mind. In this case, it's, hey, you gave us a feature and now you can't take it away. Kevin, what do you think about this?
I think this is one I'm going to be real interested to see how this comes out. Personally, I'm following with everybody else. I'm in the Nintendo family camp. I don't personally own a PS3, but I know people that do. And certainly some of the nice things, that have come out in the like, for example, the set-top box space, the XBMC is, built on top of the Xbox Media Center. Just to give you another example of something that's, built on top of a consumer device. It's going to be real interesting to see which side is actually going to prevail in this case, because as the manufacturer, they certainly can come on and update it to reduce functionality that, in their opinion, it was never intended to have. These people who are running bootloaders and putting additional software on their home device are exploiting that particular loophole. I mean, these things were never sold explicitly with the understanding that you could run Linux on top of them. It's just sort of an expectation that's arisen because it's usable that way. I know. So yeah, because you can. I mean, sort of in geek circles, people know that there's certain netbooks that you could buy because they're easily to hack into Hackintoshes, which is sort of a slang term for a Macintosh running on top of I want to say an IBM platform, but on top of a Microsoft or a Dell laptop. And those particular things certainly never sold with that understanding that they could be modified that way. So let's say look at things like Boxy. They take the Apple TV. And there's certain bootloaders you could run on it to get it to be able to load the Boxy software on top of it. If Apple should come along and says, I'm sorry, you're not going to be able to do that, and they're going to release an upgrade to the Apple TV that takes away that functionality, you're going to get a lot of upset people. Well, maybe not that many because I don't know how many they've really sold. But that's just another example of things that are built on top of common set-top devices. I know the PS. What's the name of their little handheld?
The chat room will tell us. I don't own one, but I know what you're talking about. The little black things.
Yes, that's another one that's quite commonly hacked
Yes.
and used to run all sorts of things that
PSP.
People never intended. The PSP, yes, that's right. That's certainly one that's been modified that way. So again, I'm real curious to see which side is actually going to prevail on this, because it was never an advertised feature. So like from a consumer protection standpoint, like if they said, look, you advertised it as being this way, and now you're taking away an advertised feature, that certainly is one issue. But I don't think that's these facts.
No, I don't. And I think this is real indicative of where devices in our modern world are going, that we have so much technology in our lives, and increasingly, of course, we'll have more that are essentially computers, but are not the kind of computers that, we've grown up with in the IBM clone and early Macintosh days, that where you could, go in and mess around with your computer to your heart's content, and nobody could say anything to you about it or alter something that you had come to rely on. Xeni, I know that Corey, and we get to have him on the show in a couple of weeks, so I'm looking forward to asking him about this directly. I know he opted out of the iPad and is kind of concerned about this universe where people are getting wedded to devices that you can't actually control yourself, and where somebody else can pull the rug out from under you the way these PS3 plaintiffs are complaining about. Do you have any thoughts about this brave or not so brave new world we are embarking upon?
I understand those concerns, and I share many of them. I think philosophically we're on very close ground. I'm still really enjoying using the iPad. I will also enjoy exploring what devices follow. Hopefully some of them will be architected a little differently. And again, we'll have that same kind of healthy competition in the tablet device space that we now enjoy with netbooks and laptops and desktop computers. But I would also caution all of us who think that this is such a precious and important issue to remember that for most people who are potential buyers and users and sharers of devices like that, these arguments are as abstract as particle physics. They mean nothing to a lot of people. And a lot of people just want a device that is affordable and very easy to use, and something that is not as intimidating as even a keyboard and mouse interface is to some folks, to children, to people who are of a certain age that never kind of got computers. The idea that you have something that is so gracefully designed with a UI that's just kind of so beautiful and simple and elegant, you can pick it up and kind of instantly understand how to use it. That trumps these sort of abstract rights issues that maybe haven't been communicated as effectively as they should be to the masses. I think that there's a communication problem there, and there's also a problem that, what's the alternative? What device works as well as this does with that kind of form factor and that kind of portability that also addresses some of those openness issues? Right.
Well, what this is reminding me of is another platform that is not a bit of hardware, but instead a web service that has been easy enough for people to get their hands around, that they now have, gosh, I don't even know how many tens of millions of users that Facebook has, but it has managed to gain traction through the kind of ease of use and desirability of function considerations you were raising, Xeni, but it also has its host of control and other problems. I really liked your post about the lame-tastically lame New York Times interview. Why don't you tell us about that and why it was so lame-tastically lame?
Well, there was a more adult and offensive headline before, but I was reminded that we kind of need to keep our headlines safe for the feed aggregators. So there was this New York Times emailed Q&A, it looked like, with the chief public policy communications director for Facebook. It was also a lame-tastically lame title, if you ask me, but he was a spokesperson for Facebook, and he was asked questions that were sifted through by New York Times reporters or editors from readers related to the whole ongoing, unfolding privacy Chernobyl, as we've been calling it at Boing Boing. And I think I was reading on Dan Gilmore's Twitter feed that somebody was saying that the results read like it read as if the New York Times took a prepared statement from Facebook and then just sort of chopped it up in little bits and added user questions into the relevant parts. But there was no real kind of, punching somebody in the gut and asking them for the real answers. One difference between this and the iPad issues that we were talking about earlier, do you need to be able to open up your computer? Does anybody need to be able to sort of open up their car and look what's under the hood? Do people care about that? The difference between those kinds of abstract issues and this set of issues is, for better or for worse, a lot of Facebook users who don't normally consider themselves digital privacy rights advocates or tech know-it-alls are absolutely up in arms over this stuff. Another New York Times story that followed, I think just 48 hours later, this ridiculous profile of the, the four, 20, 22, 24-year-old NYU students who are saying that they're creating this thing called Diaspora, which...
what is this? I've heard so much about it this week.
Touted as an open source alternative to Facebook. We were talking about this last night over email, myself and my fellow Boing Boing editors, and Rob Beschizza, how was it that he put it? He said, at this point, it's like putting a lawnmower engine on a wheelbarrow and calling yourself an open source Toyota. It does, as far as I know, these dudes haven't even written a single line of code, and they're sitting there with their lip piercings and the funny encoded dirty words behind them on the chalkboard while the New York Times takes their portrait. The article's all about the kind of glamour and romance of pizza and ramen and, coding in all-night sessions. Dudes, I've got news for you. I've worked in a few startups over my time, and I know that projects that are thrown together like that without a reasonable development timeline and without the kind of slow and patient guidance from other people who've been through these wars before, you end up with you're a kludgy product or something that is so difficult to use that you don't have much chance at user traction. From what I know about the theory behind this piece of promiseware, it sounds too complicated for most of the non-tech savvy folks who call Facebook their primary interface to the internet. That being said, God bless them for wanting to create something that is more honest and more responsive to users' privacy needs. But I just always, I get this knee-jerk defensiveness when somebody gets that much press without having written code and without having released it for people to kind of poke at.
Right. It has been quite interesting to watch that unfold. But I guess, the New York Times piling on the wave of stories that have been in the last couple of weeks about Facebook and privacy and security has wanted to hang its hat on some sort of white knight alternative.
And that said, these guys may not be the white knights, but they're not the villains either. And I've received a number of emails over the past few days since that story came out from other people who tell us that they've been developing open source distributed social networking services for some years, and won't you please pay attention to us? And I think what all of this adds up to is that there is an incredible kind of attention storm of excitement around the fact that people feel that users have been done a series of injustices by Facebook. There's real concern about the accountability and intentions of some of its founding fathers. And people realize the vulnerability of depending so so centrally on one service that has so much information about you and so little accountability to you.
Right. Another follow-up on that, but first, somebody has their phone close to their microphone. Marty, is it you, perhaps? We're getting a little bit of that feedback. I don't know. It's not me.
If it's
Kevin's
me,
is in the other room. So, yeah, if there's a phone near a microphone, please take it away. And Xeni, why do you think that the New York Times, of all people, followed in the reputed steps, according to the folks who were at South by Southwest that year, of Sarah Lacy when she interviewed Mark Zuckerberg? Why are people treating this company with kid gloves, and do you think that that's going to last based on the kind of information that's been coming out?
Well, so the recent New York Times Q&A wasn't with Zuckerberg, but and I know that you know that, but I mean, look at not to rag on the New York Times too much either, but let's remember that for the past, God, I don't know how many quarters, Facebook and Zuckerberg, as its poster boy, have been the absolute darlings of the tech and business press. The fact that this one company has managed to aggregate so many millions of very loyal users, and again, many people really look to Facebook as their interface to the internet. It's the one reason that many people care about being online, so that they can have that kind of ambient social connectedness to family, to friends, to people that they have a real connection with, not to strangers or to abstract ideas or things that you can buy on the internet, but to the most important things in our lives, the people we care about. The fact that these guys burst ahead of the pack so early and maintained that, and all of their early competitors, does anybody care about MySpace anymore? Friendster, Orkut, right? Tribe.net. I don't think many people really care about these services anymore. A lot of musicians that I know, will email us at Boing Boing saying, could you go back and change the link on this post from our old MySpace address to our Facebook address, right? That kind of momentum that has built up so strongly in the press, pro-Facebook, pro-Zuckerberg, I think takes a while to turn around. And honestly, journalists don't like to admit that they were not critical enough. Nobody likes to admit a mistake. And I think that this is showing that some of that irrational exuberance on the part of the press may have been a mistake.
Right, and we should point out too that the New York Times has alternately, I guess this was on the front page. Marty, you sent it to me. This amazing infographic entitled "Facebook Privacy: A Bewildering Tangle of Options."
That was a terrific infographic, and we do love our charts over at Boing Boing. That one's a doozy. Yes. I think in that same infographic, they point out that the privacy policy of Facebook is now longer than the United States Constitution.
Yes, it gives specific word counts.
It's a great piece.
Of how its privacy policy has expanded over the years from 1,004 words in 2005 to over 5,800 words as we sit here today, and some comparisons to various things that's longer than. Marty, you sent this my way. Any thoughts about the rather Byzantine process set forth here?
Well, do you agree that I win the argument we had last week? The argument we had
about needing a simple guide to Facebook?
It was just the point I only tried to make was that I don't understand Facebook's privacy, that I can't. I'm always asking my wife, how come I can see this person's photo? Who can see this person? I mean, if he's my friend and he responded, do all of my friends read his response? I said, I don't think people any longer understand it. It was always complex. It's always changing. And I thought it'd be great to just have a parent's guide to privacy settings, to which Denise then sent me two from YouTube.
Well, they weren't specifically parents' guides, but yes, people are out there scrambling to explicate how to navigate Facebook's privacy settings. And in fact, I'll go ahead and I have a tip of the week for us here, and I'll interject it here since it's topical. Jason Perlow over at ZDNet has had a whole series of posts about Facebook and privacy as all this has been unfolding. And he did a 20-minute, and it's telling that this video is 20 minutes long, a 20-minute video on how to lock down your Facebook profile. Jason Perlow at ZDNet, I'll stick it in the show notes. It is well worth your 20 minutes of time because, and I haven't made it all the way through his step-by-step video, but I was impressed that within the first 5 minutes or so of listening, he was telling me things that I, who consider myself a fairly savvy Facebook user and also have considered my account fairly locked down, never thought to tweak. So, it sort of takes this New York Times infographic and puts it into a step-by-step how-to. So definitely go check out Jason's guide and consider whether you want to follow the steps that he outlines there. Any other tips that anyone wants to share, either Facebook-related or non-Facebook related? Kevin?
No, I wanted to point out, I'm sorry to butt in. I wanted to point out that just as we went live, I noticed that I got an email from a Boing Boing reader pointing out a search tool that shows some of the intimate and disturbing information that the new search API makes trivial to implement. I'm not going to blog the URL right now because some of the people whose Facebook information is accessible through this probably have no idea what this makes possible. But long story short, you can click on a term like cervical cancer and see many strangers tweeting about the fact that they just came back with positive results on a cervical cancer screening, or people, you search for the term HIV, and people talking about just having had HIV/AIDS tests and coming back positive or negative.
Right, so these are people's status updates in Facebook, and you're not their friends, but you're...
I don't know them, and I'm not logged into Facebook.
Right.
But some of this, I think, points to an issue that's even bigger than Facebook, as big as Facebook is, about our sort of collective awareness of what is private, what is public, and the user's responsibility to establish and guard those boundaries. I think that poor design and poor communication on the part of a hugely popular service like Facebook is to blame. But, it's like talking about McDonald's food making you fat also, right? We could sue McDonald's and ask for McDonald's to be shut down, but maybe those of us who patronize McDonald's also need to think about what food we're putting into our bodies. I think the same is true here, that there needs to be like some kind of massive public education campaign to remind people that just because the service is easy to use, it's also really easy to share things that are absolutely inappropriate to share and that you wouldn't want to share.
Mm-hmm. Yes, I saw something just as we were going live too that had something to do with information available to Yelp through the API that was, I don't know if it's the same, Sheni, that you're discussing, but it was revealing a whole bunch of stuff that people didn't necessarily know would be out there. So yes, there are ongoing issues here. Any other tips anyone wants to give before I have a couple of other Facebook points to raise and then our Audible pick? Kevin, any tips of the week you want to give?
Oh, just one quasi-Facebook related, something that seems to come up every so often. Everybody comes forth with a new Facebook is going to do this next rumor. So I certainly would suggest people check out Snopes.com, SNOPES.com. They do a wonderful job of explaining what is reality and what is merely an urban legend. Just this last week, I helped settle a dispute. Some people here at the office were concerned that Facebook is going to start charging its users for access, and they were upset. And it's like, no, I don't think Facebook is going to be doing that.
Yes, Snopes is ground central for fact-checking your ass, which is something that the web does so well. So that is
I would say Snopes is a wonderful resource for quashing those false Facebook is going to do this rumors.
Right. Marty, any tips you want to share?
No, I'm thinking about how in the real world, we have multiple social networks, and we have learned that there are some people you can tell that you have illness, and some people you would not ever tell, and there's some people you would share information that you're hungover, and some people you would never tell. And that we have a bunch of competing social networks in our lives, LinkedIn and Twitter and maybe smaller networks. But Facebook has become the default social network of our lives. And my collection of friends is a strange collection from my public school and from college and from law school and clients and business colleagues. And there's virtually nothing I can say that would be appropriate for all of them to hear. So the solution is either we're going to disaggregate Facebook and go back to belonging to 10 different social networks so that we can broadcast, as I did last week, that my niece was born or something like that, to only those who are interested in hearing that. Or Facebook is going to have to become a whole lot more powerful, and there's going to be the colleague status update and the relative status update and my friends from PS214 and Flushing status update.
That seems like such a trivial design problem. It's a wonder to me that hasn't been implemented yet, either by Facebook or by a competing network. I mean, to me, a lot of times when I think about this problem, I think about just Facebook and other services like it, even Twitter being kind of a big, blunt tool, like a mallet. And what we need is something more refined that, as you said, Marty, allows us to I talk to my mom about things that are different than what I talk to my boing boing buddies about, and that's different than what I might talk to a significant other about.
Absolutely.
Well, I guess I can cobble a tip together out of this discussion. I think there is a way when you are adding people as friends to create lists, right, where they see either your limited profile, which can include your status updates or not. Or I think you can create whatever sorts of lists that you want as far as, friends, family, clients, what have you. And then when you go through, and hopefully Jason Perlow's video will further explicate exactly how you do this, you can tweak things like your status updates to only be available to certain groups. But as I talk myself through this, I see that you're making that decision not on an item by item basis, but on an object by object basis. So you have to say, okay, all my status updates are only available to this group, and that's not a great solution either. So there you go. Xeni, any tips before we I want to talk about the login security that Facebook has just instituted too, and get your thoughts on that. But any tips before we move to that?
I think that we've covered a lot of that. I'll be interested to watch Jason's video. Honestly, like the only tip that I can really offer that seems solid at this time is that if all of this seems bewildering to you, consider filling your Facebook profile with a bunch of junk data and then actually deleting it until all of this stuff is sorted out. I am considering doing that myself.
Right. Well, okay, that's our tip, and that's another topic I wanted to get to is what happens when you delete a Facebook profile. You did an interesting post on that, Xeni. What is going on with the data? When you've actually had enough, you're not going to take it anymore, you go in, you follow all the Byzantine steps to delete your profile.
Well, even with that recommendation, that comes with a caveat, and the caveat is we don't know what happens with your data. We do know, thanks to public radio reporter John Moe, who recently took over hosting and producing duties at the Minnesota Public Radio show Future Tense. These guys did a really solid investigative report on this new radio show about what happens when you delete, not deactivate, but actually delete your Facebook profile. And what they found was that Facebook reportedly said that they will use that information as long as they feel like it for data mining purposes. John and his team asked if they will at least anonymize that personal data. Facebook wouldn't reply. So even if, say, when we end this call, when we end this This Week in Law episode, and I go back and say, I'm mad as hell, I won't take it anymore, I'm going to just add a bunch of lorem ipsum text to my profile and defriend everybody and then delete and wait 2 weeks and see what happens. Even then, I have no idea what these guys are going to do with my data. And I'll also say that when I joined this service, I thought of this as, I use it pretty much the way I use Twitter. I never publish anything that I wouldn't be afraid to have, show up on Gawker 48 hours from now. But that said, even the nature of who I connect to using the service, or any like location-based events that I might reply to in a moment of stupor and not paying attention, not really thinking about the privacy implications, all of those things, like there are privacy implications that even those of us who think we're really smart might not foresee. So even if you're not talking about the birth of your daughter, or the new home that you bought, or the preschool that your kids go to, or where your checking account is, those are obvious things, but the aggregate of your activity and of your connectivity on the service, even for the most lightweight users, does present privacy problems and data mining value for the service. Bottom line, I don't know what happens when you delete your account. Neither do you.
Right. And Zach Whitaker, we also have we have a link to both to Shenny's post and to Zach Whitaker's post over at ZDNet, where he did some experimenting as well on creating a false account and deleting and trying to see how long thereafter the actual photos and other things would be available online. And it was, at time of publication, it had been something like 6 months and stuff was still there. So,
Roche Motel.
Yeah, the persistent URLs may not be publicized, but the things are still accessible if you know them. So one way in which Facebook is trying to make some headway on maybe not the privacy front, but the security front, is by adding more security measures to ensure that it's really you logging into your account, and so that only you can see that data and actually make changes and portray yourself as you. They're testing a feature that lets users pick which devices they prefer to use when logging in. And then if a login request comes from an unknown device, that you get a user notification, and presumably you would be locked out until you gave enough authorization to ensure Facebook that, yes, this is me. I just happen to be on my friend's computer checking things. So I don't know that this makes me feel all that more secure. In fact, it sort of goes to the discussion we were having before about people inserting controls that you might not necessarily want there, that actually interfere with your ability to use a device or service in the way that you would like to, and that is most flexible. Kevin, is this going to make you sleep better at night?
Well, I think they're finally adopting certain technologies that have existed in other contexts. I know my bank has done this for years, being able to prove that who you are. You log in from an unauthorized device, and they're like, "Wait a minute, is this you?" And you have to go through a set of steps to prove that it really is you. You've just got a new laptop, and you really do intend. This to be an authorized transaction. I think it's about time that they're implementing that on a service like Facebook, where this information can be shared. So I don't know if necessarily going to sleep better at night. I'm an avid Security Now listener, so I know that cross-site scripting and some of the other issues that prevail with information that's stored on the particular drive that's used to authenticate identity could be used for other purposes. So they might be able to tell that look, this person's got a Facebook cookie, and go out and attack it.
Marty, you asked me before the show if I think your hypothetical was if an alien landed and asked you to sum up the problems with Facebook in 30 seconds or less, what would you say? And I gave you my response, and I said management issues. What would you say? And do you think that this security measure begins to address the problems?
but you didn't respond to my reply to your email, which is, what did you mean about poor management? How is the poor management hurting people? With regards to the security login, it doesn't make me sleep better. I mean, Benadryl would make me sleep better and little else. My worry is not so much that someone's going to... I suppose I should be worried that someone should hack into my Facebook account and update my status. I should be more worried that someone hacks into my bank account. I'm more worried about the things we're talking about, what Facebook is doing with my data, not what a hacker is going to be doing. So I can't say that this is a bad thing. I just don't think it's an important thing.
Yeah, my fear about it, and I think it's just a test at this point, they haven't rolled it out widely to users, is just that it's going to be annoying. You know, I do jump from device to device quite frequently, and to have, actually it's I think more of a privacy issue to have a responsibility to log all my quote-unquote authorized devices with Facebook in order for them to know that it's truly me accessing the site. It's a catch-22 for them, to be sure. They have to try and protect accounts as much as possible. They had this other snafu this week where somebody had, 1.5 million accounts that they had access to that they were offering for sale. So, you know, obviously they've got to address it somehow, and kudos to them for making the effort. I just want it not to interfere with the user experience as well, which, of course, is something they must struggle with all the time. What I want to do now is go ahead and thank our sponsor, Audible.com. We love listening to Audible books here in my house, and Ernie Svensson sent in this great recommendation for a new book on Audible that I hadn't listened to, but now that I've downloaded it and begun to listen to it, I've immediately purchased copies for all of the fathers in my life, because we are the kind of family where this would make a good Father's Day present. It's called, and I will amend the first word in light of our clean tag on iTunes, Stuff My Dad Says. It's actually not Stuff My Dad Says. That arose out of somebody's Twitter account. Fellow who was living at home with mom and dad. His name is Justin Halpern, and was so taken by his dad's 73 years old, his witticisms. He's sort of a very rougher-edged Yogi Berra. Says things like, do people your age know how to comb hair? It looks like two squirrels crawled on their heads and started copulating. And so what he did was he started, and I think actually this is an interesting pick for the substance of our show too. He started just posting these wonderful little witticisms of his dad's up to Twitter. And as you listen to his introduction to the book, he tells you, you know, at first he had a handful of followers, and then he had 1,000, and then he had tens of thousands, and then soon 300,000. And then a book deal came his way, and a literary agent, and TV show invites, and reporters calling him up with questions. And meanwhile, his dad didn't know a thing. You know, these were arguably his father's intellectual property or whatever else. And who knows what sort of privacy interest could be asserted into these things that he's saying simply to his son. But they're all out there, and now they're a book. And I'm just getting now to the part of the book where he's actually going to have to deal with the repercussions of his dad learning that all this was publicly available and going to be a book. And you can listen to that book yourself on audible.com. Go to audiblepodcast.com/TWiL, and it can be yours for free. You can then be signed up for the Audible Gold listener program, which gets you a credit a month for a book for the low price of $14.95 a month. And Audible now has over 70,000 titles. It gets wonderful things like this. And I've got to say the reader, Sean Schummel, does an excellent job of giving personality to the father and the son and all the other characters in the book too. So it's quite a fun little tale that grew up from Twitter of all things. So check out audiblepodcast.com/TWiL, download this or whatever other title you would like. And thank you so much, Audible, for your support. Follow Audible and get recommendations for new books at audible_com on Twitter. So before we leave that, anybody, Kevin, how about you? Any thoughts about the father's rights in this situation where a son decides that he is witty enough for publication and takes that into his own hands?
I certainly think he could possibly have a parental concern. He's got certainly ownership in his statements. Whether they were fixed in any sort of tangible medium of expression until the son wrote them down onto Twitter is another matter. It's the son that did the fixation, the actual
that's
recording.
That's an excellent point, yes. Marty, any thoughts on this?
Well, I've been a fan of that site for a while. And I think it would be in keeping with the character of the father to sue the son. I think it would drive sales of the book.
Absolutely. Xeni, did you know about this? I'm sure you did, being the maven of all things tech cultural.
Yeah, I've been following the account for a while, and I remember when I was watching Keith Olbermann's show, I think earlier this week, he mentioned the book or did a little segment about it, or he seems to reference it periodically. I think Olbermann's a big fan of it. I love Audible, by the way, and I'm not paid to say that, but I love their services. I'd like to see that fake AP style handbook get a book, because, man, I'd use that to blog with every day. Have you guys seen that Twitter account? I hope they get a book deal.
Yes, I think I'm following it. I love it when their tweets come through in the stream. It's quite humorous.
Yeah.
Mm-hmm.
So let's talk about, since we're on Twitter, let's talk about something else that happened this week. The forced follow bug and resetting everybody's follower accounts to 0. And I actually think there's a legal angle to this as Twitter becomes more and more commercial. We have folks that are relying on it for their promotion and publication, their online presence. And it definitely, I think, has a commercial role in people's lives. And the follower count in particular, has something to do with reputation and status and reach and everything else. And it magically went away. Now, of course, it was restored as soon as possible. It wasn't intentional. And I'm sure that Twitter's terms of service completely cover them from this kind of an event being actionable. But I thought it was an interesting thing to bring up, particularly in light of the PS3 case that we discussed earlier, where a known function or use went away and resulted in a lawsuit. Xeni, you had some fun posts about all this. Why don't you lead off?
Oh boy, where to begin? This was just absolute comedy gold. It was like watching a really good late night comedy show unfold in 140 characters at a time. And I say that because specifically, all of the celebrities in my follow stream, all of the famous people that I follow on Twitter, just as like the humble geeks were saying, "Oh look, there's a technical bug. Let's hope that Ev and the team fix that shortly," and sort of chattering about the technical issues. All of the celebs were saying, "Where are you? You guys, did I say something? You don't love me anymore. Guys, come back." And you could just, I mean, yeah, okay, part of why they're there is for commercial reasons. Part of it is for publicity. But they're also just such thin-skinned, narcissistic egomaniacs. And it made me think, like, I actually kind of enjoyed Twitter a lot more when it was, me and 5 of my friends. and it wasn't all about ego. So you could really look at who was flipping out and saying, "Oh, this must be me," right? The fact that my follower count is 0, everything's about me. It's all about me, and I must be responsible for this. Jesus. And then 20 minutes later, some of their followers actually replied back, because you could still get @replies. It's just that your count looked like it was at 0. So some of their fans who were still following them schooled them and said, "Dude, get a grip. It's a software bug. Or it's a system fix." They said, "Oh, I knew that. Ha ha," and then trying to make jokes about it. It just showed how pathetic human beings are, and particularly famous pathetic human beings on Twitter.
And how difficult it is for common folk or uncommon folk in the case of some of the thin-skinned narcissistic egomaniacs you're referring to. The whole concept of technology and its foibles is sort of lost on them. Marty, any thoughts on this?
I didn't go onto Twitter that day. Wish I had. Nothing constructive to add.
Well, there we go. Well, Xeni, thank you for explicating the humor of it all so wonderfully. Just as fun to follow along with the actual tweets that were happening was your coverage of them. So
it boils down to this.
Exactly. One other sort of potential actionable or not actionable, but illegal implicating feature that Twitter has rolled out recently, sort of lost in the shuffle between all the crying about the lost Twitter follower counts, is they made tweets embeddable, like a YouTube video can be embeddable. And I just wanted to toss out to our lawyers here and have you guys explicate, if you could, why that's just fine, or is it from a copyright standpoint? Kevin, why don't you go ahead and bring us up to speed on that?
Well, sure. If I can just briefly say, technically what they're doing is they're allowing a particular tweet. Some people may not realize that each tweet that you make is individually identifiable, and if you know its particular number, you can link to a particular tweet that a user makes. You don't have to list just a particular profile. You can link to a particular status update. And now there's a particular piece of HTML code that allows that tweet then to be displayed in a rather nice looking fashion on a particular website. It's like a copy and paste goes into a particular post, and that particular code will then display the tweet with a nice a graphic bubble around it that makes it look pretty. And so from a terms of service standpoint, you certainly allow Twitter to take your tweet and display it through other mediums, such as through the service itself, through its API, through the different clients that people have. People might have a Twitter client on their phone. People might have go access it through the browser. Some people might use a service like TweetDeck to do it. So you certainly are allowed to display it through other means. And this is just one more method of display that makes it easy for people to reference a particular tweet in a nice graphical, visually interesting way.
Xeni, were you making use of this new embedding feature? It's nice not to have to do screen grabs when you're pointing to crying celebrities.
I haven't used it yet, but I think it sounds great. I have done that a number of times, where we do little screen grabs and then we insert an image. It's I think it really makes sense for bloggers because more and more often I find myself looking to individual tweets as kind of an already automatically on the record comment from public figures or from people that I think have something interesting to say. So yeah, I'm all for it.
Great. Marty, any thoughts on turning tweets into things that can be propagated around the web a little bit more easily?
This is the first I've heard of it, so this is me thinking about something. I'm trying to distinguish this from a lawsuit that was filed in, I think, the Southern District about 2 weeks ago, which you may or may not have spoken about on the show, which is that someone took a photograph of a news event and uploaded it to Twitter, probably using TwitPic or something. I'm pretty sure that AFP, the French news agency, reproduced that photo and ran it on their news service without attribution and without payment. And in their answer to the copyright infringement suit, they said, "Oh, haven't you read the Twitter term of service? When you uploaded the photo, you gave this, eternal exclusive license to allow republication." And just glancing through the complaint, my reaction was, no, they granted Twitter that license. They didn't grant everyone on Twitter, especially those who don't follow you, this eternal license. In other words, you didn't completely abandon copyright merely by uploading something to Twitter. On the other hand, I certainly agree with Kevin's point that there would seem to be an implied license when you tweet to allow various forms of reproduction and reformatting, such as allowing it to be reformatted for TweetDeck or whatever. So that sort of sounds okay, and AFP sort of sounds wrong, but that's just off the top of my head.
Well, yeah, Marty, I think one interesting point about this is that the old way of doing it, as Xeni said, would have been to take a screen grab of a particular tweet and embed a picture into there. This doesn't rely on that. In fact, my understanding of it is if the status is then deleted, people are going to have blank holes then on the websites where they've placed it.
Right, it's an inline link, the way that a YouTube embedded video is.
Right, and so it's still the author of the tweet's right to delete that tweet, and then it will then disappear from wherever it's linked and embedded.
Oh, then I won't use it because often tweets that I might be wanting to blog about on Boing Boing might be controversial statements that the Twitterer might wish they hadn't said, and people can and do delete their tweets later. So I don't want a gaping hole in our record.
Yeah, that's my understanding of it. I could be wrong, but that's my understanding of it.
Yeah, it makes sense because that's what would be fair for the user, but it's not what sneaky journalists and bloggers want.
As a journalist,
right? You want that pick. That's an interesting point, though, Marty, because I do know that YouTube has gone to the effort of, if people take the time to read their terms of service on the license that they grant when using the service, that they go out of their way to ensure that embeddability is part of the compact with users and that folks know that they are granting a license not just to YouTube, but to the various users in the community on YouTube to be able to reuse their work that goes up there in the form of embeds. So,
I would also throw out that, I'm sorry, Denise, I didn't mean to cut you off.
Go ahead.
So I remember, I guess it was about a year back, I got an email from a company that was making T-shirts with Twitter quotes from various digerati, Twitterati that they thought were funny enough to put on a T-shirt. And they chose a line of mine that they wanted to make a T-shirt out of. I think they offered me, like $75 worth of free T-shirts and, I don't know, like a $30 gift certificate to TGI Fridays. It was something ridiculous. It wasn't much compensation. But the bottom line was that they asked my permission before using my publicly available tweet on a piece of merchandise that they were going to sell for profit, and I was not going to share in that profit. If somebody came to me again like that, I'd probably say no or ask for real money. But that was interesting to me as an example of how, I don't know what the law is behind that. Certainly anybody can repost anything that I say on Twitter on their website, be it a big blog like the Huffington Post that makes money, or just some random high school kids' live journal. I'm okay with that. I'm interested in knowing what the law says about, could CNN use something that a random person on the internet says that's not, an at-reply to Anderson Cooper or Rick Sanchez? Can a movie director use like a screen grab or video of a flow of tweets, in a big movie that's going to make big money at the box office? Did the T-shirt company have to ask me before using my tweet on their T-shirt?
I think they did. We had a show a few weeks ago with Merlin Mann, who was complaining and having some discourse with some folks who published a book of tweets that were compiled and included a great many of his without authorization. And I think that, I come down on the side that they are copyrightable and protectable, and that if you're going to do something, if there's a fair use analysis that comes into play, and part of that analysis is the commercial nature of the use, and then there's the transformative nature of the use and the various other factors. But I think the commercial one's a huge one for the courts. And, as soon as you are making money off of directly copying something even as small as a tweet, I think that you're in that realm where you better get it licensed. Marty, do you agree?
You're absolutely right. First off, the small tweets are potentially copyrightable. And something like reporting that there was such a tweet can fall within fair use. But something that transforms it, such as putting it on a T-shirt, is very likely not going to be fair use.
I think I know about the book in question that that your previous guest was upset about, and my gut reaction would be the same. That feels like a douche move. It seems unfair, and it seems uncool, and it doesn't seem like it was done with goodwill or sort of common internet etiquette. But that said, part of what worries me as somebody who thinks about fair use on the internet every hour of every day that I'm blogging on Boing Boing, because we have gotten into trouble on that, where people come after us and say, we didn't want you to blog this critical thing about our company, so we're going to sue you unless you take it down. That makes me wonder. Let's say that a public figure, a celebrity or a politician who's in the middle of some controversy, tweets something, and I notice it, and I put it up on Boing Boing, or let's say that ends up in a book that I might write about history of politics in the 21st century as told through tweets. It makes me wonder how much of this is just going to generate billable hours for attorneys, and how much of it is going to impede the rightful flow of social discourse.
Well, that's a fantastic segue to a link in our show notes about whether attorneys are going to be the death of the coming Star Trek universe. The Star Trek future will never happen thanks to lawyers. Wrote Adrian Kingsley Hughes over at ZDNet, and he has a great piece about how liability is killing various technical innovations that he wishes would happen. What do you think, Marty? Or should we just go ahead and commit seppuku right now so that we don't stand in the way of progress?
I am absolutely offended by that position, and I will have you know that I represent a company called MakerBot, which is a $750 desktop fabricator, and it is the first thing that is going to lead ultimately to the machine that allows Captain Picard to order up Earl Grey hot. So
awesome.
I
am
love that
working hard to make the Star Trek future come about.
I want to use a MakerBot to burn my own tricorder. I've always wanted one.
I'll put you in touch.
Yeah.
Employee discount.
Jenny, you sent me an email that said it was sent from your tricorder, and that made me laugh for about a solid 5 minutes.
Hey, I can put it in my SIG file, but that doesn't make it real.
Kevin, what do you think? I mean, lawyers notoriously have a bad rap for making progress a slower thing than it otherwise might be. Do you think that that's improving or getting worse?
I think lawyers are, going to be bashed throughout time. My friends on Facebook will know that, I'm a tremendous science fiction fan. And Star Trek is just one of my many fandoms that I'm, enamored with. But I'm thinking back when I read that article to the original Star Trek: The Motion Picture with the transporter accident at the beginning of the movie. Something like that. Certainly, it would have been over-lawyered if it had happened in today's culture. It's just a massive, lawsuit waiting to happen, and as opposed to just the tragedy that it was to those particular families. But it was like I said, it's just the first thing I thought of when I read that article. We as lawyers, get bashed for the things like, the product liability lawsuits and the too hot cup of coffee, the all sorts of other, the overlawing of America, the class action mentality.
Yes, tort reform.
And
we're
I think that
talking
feeds
about
off
the
that.
basis for why people get on their soapboxes and talk about that. And when we're not perfect, we lawyers, it tends to have comical and public consequences. We can't have Marty on the show without highlighting some ridiculous trademark disputes. And recently, was it Gucci accidentally sued Chanel and then didn't sue Chanel and apologized. Do you want to tell us what happened there, Marty?
Okay. So here's the problem. You only report when man bites dog, Denise. Every day, trademark owners wake up and there are people who are counterfeit their products, and they file a lot of lawsuits, sometimes many in the same day. So a group of luxury brand owners, Balenciaga, Gucci, and some YSL, they filed 2 lawsuits in the Southern District of New York, and it was against a bunch of websites that were allegedly selling counterfeit bags. And as is the case, they try to name lots of different websites at the same time. And one of the websites that they identified was mypurseworld.com. So they sign the complaint, and then they file an application for a temporary restraining order, which, to explain to non-lawyers, is the most urgent type of relief. It's even more urgent than a preliminary injunction. It is ex parte, which means they don't yet tell the other side that they are doing this. And the reason for that is, Your Honor, if we tell them that we're moving for preliminary injunction and you take 1 month to decide this, then what they're going to do is just shut business down on this website and open up business at some other website. So tell you what, give me a TRO that will give me the relief of freezing everything. I'm going to serve it on the ISP. They're going to freeze the code. I'll be able to seize things, and we'll be able to stop this for good. So they file a temporary restraining order, and these sorts of things have all sorts of allegations. And they said, here is a picture from mypurseworld.com. Here is the counterfeit bag that they're selling, and everything is in the present tense. So they get their TRO, and they serve everyone, and then they discover a problem. 9 months earlier, Chanel had seized mypurseworld.com, and Chanel had taken control of that website, and for the last 9 months, the website had said, don't buy counterfeit goods. So there is a certain problem with the various signed statements that Gucci's lawyers made, which is that mypurseworld.com is selling counterfeits, and here's a photo of what they're doing. And by the way, I'm filing a TRO, which means that all this is really urgent, even though apparently nothing had been going on for the prior 9 months. So this got some press because of the amusing Gucci sues Chanel problem. I think it's worth talking about for a little bit more profound problem, and I want to have a big disclaimer. I'm learning that anything I know about this case, I've read the court documents. I don't know the background. I know that Gucci's lawyer has put in a defense of what their actions are, and that's available, on the docket of this. So we don't really know what happened. I'll only note the following. Federal Rule of Civil Procedure 11 says that when a lawyer signs papers, we have to make a reasonable investigation that the law is correct and that the facts are correct. So at first glance, there's a problem here.
Mm-hmm.
A problem that seems to require a unicorn chaser, to borrow from Sheni a bit. So I'll toss one out there that over on Tech Dirt, they have a post up about making a power hour drinking game around ridiculous trademark disputes. Any suggestions for something you would include in that kind of game, Marty?
What they're referring to is that someone apparently has a registration for Power Hour, and the description of goods that they own the rights to is a drinking game that involves taking one shot of beer a minute, every minute for an hour. So I don't know if anyone's ever actually played that game through to completion, but apparently someone has a registration for Power Hour and goes around bugging everyone, trying to get them to stop. But look, there's always people who over-enforce their property rights. I mean, look at my next-door neighbor.
Great. Well, just to round out the show here, I have a bunch of links that sort of are updates on what's going on in Hollywood, around Hollywood intellectual property these days. The first three are sort of box wars, and harkens back to something we've talked about already today, when your devices are doing things that you have no control over. The Dish DVR Dish is being sued on various patent fronts, and now that they have gone ahead and said we may have to take the DVR function out. They're being sued by TiVo, I believe, pending this lawsuit, in light of whatever sort of injunctive relief may come down in the suit. And so all of a sudden your Dish DVR, and I'm sure that they would have to adjust their pricing accordingly, because there's probably a component where you're paying extra for the DVR function, but that may be pulled out from under users. Any thoughts on that, Kevin?
I read the same article. It might, general take on it is that they're going to be certainly in trouble if they have to do this. But even in that same article, they talked about providing replacement functionality. If the DVR goes away under the current model, they're going to have to provide a replacement function that's equivalent. And they estimated that it's going to cost them upwards of $3 billion to replace all these DVRs. And so that's certainly a benefit when you have an advertised feature and all of a sudden you're forced not to do that because of other concerns such as patents, which is certainly a valid concern. TiVo has, the right to enforce their patents in their system. And, if indeed Dish Network has done this, then, that's certainly one of the remedies that's available to them is demand that it be removed from the market.
Another sort of box-related story here is, do you guys remember the Kaleidoscape, the very high-end device where you could rip your DVDs and have them stored on the hard drive, but there was litigation about that because of the DMCA and the fact that you're not actually permitted to do that. Now they have attempted to do the same thing with Blu-ray, but it's not any more legal than it was the first time. So doesn't appear that that's going to go anywhere. Just go ahead. Someone was going to jump in.
I was just going to say that it would seem like the major difference between this one and the prior one is that this one, in order to prove that you still own the physical copy of the disc, it required you to put it in before you could play it, which certainly seemed to undercut the benefit of having a device that stores lots and lots of discs in one unit without having to switch out the discs. Sort of
points up the ludicrous hoops that you might have to jump through under the DMCA. Defeats the purpose of actually having this kind of device. But one thing that does not seem to have a defeated purpose, but one that is very forward-looking and may well undermine some of these cable and other boxes, DVD player type boxes that we've been discussing, is Netflix now beginning to make its streaming available in HD on PCs and Macs. There are some stories out there giving indications that more and more of the watch instantly material, which has been available in quote-unquote HD on devices like the Roku for a while, are now going to be available on PCs too. I don't know where that stands for iPad. I haven't seen anybody write that up yet, but Netflix seems to me like it is just charging through a lot of red tape and kludgy old technology. Xeni, with your video background and interest, what do you think of their strategy?
As you know, as somebody who's been involved in producing video content for Boing Boing, original video content for the past, it's already been like 3 or 4 years. Any creator, any distributor, the greatest concern is getting that on as many different devices, on as many different platforms, and in front of as many different viewers as possible. So the strategy, if that's the underlying concern, the motivation makes sense.
Marty, any thoughts on the future of the cable industry in general? I mean, do we really need cable anymore with this sort of service available?
You're going to have to repeat the question. I was distracted. I was just watching Mulholland Drive on Netflix right here in another box on my Mac.
In HD.
In HD. I was feeling kind of ripped off and was thinking of maybe canceling my Netflix membership because we were always leaving the discs around and holding them for a month at a time. And then they offered this on the Mac, and we are watching an awful lot of Netflix movies. And I'm really upset that I sold Netflix stock last year rather than this year. They're just
the
amazing.
iPad app is really sweet, too. I don't know if you've tried that, Marty.
One more thing to buy.
Wait, the app or the device? Are you toting one of these around? I think you said before you weren't.
Sorry, the Netflix app for iPad.
Right. But are you an iPad person yet, Marty?
I'm holding off.
Good luck with that. That's like me when I show up at my kids' school, and even though I don't drink coffee, they have the big pot available and no decaf. So
the thing was,
I have to partake.
I bought the original iPhone, and then was one of those. Bought it like the first week, and then was upset when the price went down $200, something like a month or two later. So I keep on holding out for either the first upgrade or the first price reduction. And I'm reading the Kindle on the morning commute up until that point. But we were in the Apple Store this week, and I actually touched the iPad, so the resolve is obviously weakening.
Yes, that's nothing like that to melt it away. As long as we're on Hollywood, a couple more things just to note. The RIAA has killed LimeWire in much the way it killed Grokster, and it seems to have done so a little bit more easily. However, I think that we're just at the trial court stage of this litigation, and like Grokster, there could be subsequent proceedings, but we already know what the Supreme Court has to say about all this. If you're building a business around other people's infringement, and that's part of your business model, then you're out of luck. And that seems to be what the court has concluded here about LimeWire. Kevin, any thoughts about this one? Is this just a logical footnote to the end of Grokster as well?
I think this is the first one to get to this stage with what I would call pre-Grokster facts, where they didn't have the benefit of having Grokster in mind, the decision, when they were crafting their service. There's a lot of bad facts for the people running LimeWire that were from before that decision, and it's certainly it's a fairly straightforward application of the Grokster decision to these particular sets of facts, and it's going to be interesting to see what they do next. The judge is setting it for a hearing, I believe, in June to discuss damages, and we'll see how much damages are awarded.
In this kind of case, it could be potentially gargantuan, couldn't it?
Oh yeah, they are asking for $150,000 per infringement, and if you think of the sheer number of works, that'd be a large sum.
Yeah. All right. Well, somebody else looking for a large sum is the producers of the Academy Award winning, I believe, Hurt Locker.
Yes.
Winning.
Yes.
Winning.
Best Picture of the Year.
Yes, who are going after torrenters. So if you have downloaded that via BitTorrent, beware, because they are going to, they're using a service that other companies have used. What's it called? The copyright something or other. I don't have the story up in front of me now.
It's called the Copyright Group.
The Copyright Group, yes.
And the Copyright Group appears to be a trading name for a Washington, D.C. law firm. So if you go actually look at the papers that are filed in any of these lawsuits brought by them, you'll just see it's like, name, and name, a Washington, D.C. law firm. But the website's sort of interesting. They identify themselves as a law firm, totally anonymous, the Copyright Group, without identifying the individual lawyers. So that to me is one of the more interesting aspects of the Hurt Locker case. A fine film, I might add. Right.
So it's sort of they're making themselves the bulldogs who will go after problematic BitTorrented situations. Is that fair, Marty?
It gave me a business model idea while I was reading the article about them. Yeah, some of the articles are saying, oh no, like they're going down the wrong road. They're going down the RIAA, sue your grandmother route. But let's wait and see.
Yeah, but
I think.
Go ahead. Is that Kevin?
Yeah, that's me. I think in this case, though, they've got a good set of facts, though, to show that they actually have been harmed by these BitTorrent sales. BitTorrent depriving them of sales. You look at other films that are also similarly infringed, like Avatar and some of the others, but Avatar was a tremendous commercial success, and it'd be very difficult to say that they've been harmed. Where in this case, the Hurt Locker was a critical success and an award-winning success, but I don't think it's been a commercial success. It certainly has not, drawn in the big bucks. And they can certainly say, since it was released online, I think several months before the actual theatrical release, that it severely hurt their theatrical sales.
Well, I'm sure they will in their lawsuit.
Right.
Sheni, what do you think about the notion of going after users? And do you really think that producers, no matter how early a film is leaked, really should be targeting their fans in this way? And is there a better business model that could develop to address this issue?
I understand that they have a good legal case, and I understand, come on, I've spent time around filmmakers, I've spent time around people in movie studios, and I understand the motivation. These guys are, at the end of the day, also trying to make a living. But this just seems like this has never worked. There's no precedent that says that suing your fans ever works. There's no precedent that says suing individual BitTorrent users stops the problem of movie downloading, unauthorized movie downloading. There's no precedent that says that this does anything to stem the flow of piracy. So I think the net result out of this is probably going to be a lot of ill will towards the folks behind this film and all involved in the lawsuits. And I don't think that at the end of the day, this is going to make Hurt Locker any more of a commercial success. Note also that this is happening long after the horse is out of the barn, or whatever that aphorism is. The movie's been out for a while, This is not something that's leaking prior to its release. I might have had more empathy for the folks behind the lawsuit if the infringement and the legal fight happened before this hit theaters. But the movie's kind of old news at this point. I don't get it.
Right, and now their revenue is coming from the post-theater sources, such as Netflix. And I didn't catch the name of the person who posted this, but someone on Twitter said, was so offended by this move on their part that they said, hey, I had this in my Netflix queue and I just booted it out of there because I just don't even want to see the film now.
It's hard to put numbers on things like this. It really is hard to quantify exactly what damage adds up to. I know that lawyers get paid lots of money trying to do exactly that, but at the end of the day, we don't really know exactly, we don't know whether the makers of the film, The Hurt Locker, sustained more damage with these unauthorized BitTorrent downloads than they will now with all of the intense bad will from well-informed consumers who think that that's kind of a jerk move for them to have pulled. Stories exactly like that of law-abiding folks who might have enjoyed downloading this off of Netflix and paying for it, look at this and say, this is stupid. This didn't work for the RIA, it hasn't worked for the MPAA, and it's not going to work for you.
Well, on that note, I'm going to go ahead and go around and have you guys tell us any last things that are on your mind, and we'll wrap the show. Marty, I really appreciate your coming back on the show. Anything, any parting words, parting thoughts you want to leave us and our viewers and listeners with?
Yes. I read the book, How Fiction Works by James Wood. James Wood is a lecturer on fiction at Harvard and a editor of fiction on The New Yorker, and his book is available on Audible. And it is, in one way, a textbook on the elements of fiction, but it is amazingly written narrative. And I find that it helps my advocacy writing because it reminds me that when I'm writing a brief, I am telling a story. I am delivering a narrative, and it helped me make my narrative more powerful. How Fiction Works by James Wood on Audible.
Great. That'll be a second Audible pick for our show. Thank you so much, Marty. And folks, you can find Marty on the web at schwimmerlegal.com, the trademark blog. And you can follow him at schwimmerlegal on Twitter. So thanks so much, Marty. It's been great.
On Trademark Blog on Twitter.
Trademark Blog on Twitter. I'm sorry.
Remember,
I've gotten that wrong twice now.
2 accounts because I have multiple social networks.
Right. Well, you have an at M. Schwimmer.
At M. Schwimmer is the personal one. So if you want to know about my niece, go to M. Schwimmer and the law at Trademark Blog. At Trademark Blog,
which is also the wonderful destination for all things trademark and coverage of very many interesting points and nuances that Marty goes through day by day on his blog. So thank you so much for that, and thank you for joining us on the show once again.
Thank you, Denise.
And Kevin Thompson, How about you? Any parting thoughts for folks as we sign off here?
Sure. Marty picked a book in his pick. I can do the same. What I was thinking of was a great recent book by Jim Butcher. He's a wonderful science fiction author, and I was very, very happy to get my Dresden Files fix. These books come out once a year. The 12th book just recently came out called Changes, and it deals with a wizard that lives here in Chicago who advertises in the Yellow Pages that he's a wizard, and he's available for hire. And the Changes is the 12th book. It is on Audible, but I actually would recommend starting with the first book, which is called Stormfront, which is a great book as well. The protagonist, Harry Dresden, is sort of a badass wizard who helps people solve crimes. It's a great book.
That's a great mashing together of genres there. I was looking forward to checking that out. And it's here in Chicago. Yay!
And it's set here in Chicago. It's a wonderful series.
Cool. Thanks so much for that, and thanks for joining us on the show. Folks can find
Kevin thanks for having me
at cyberlawcentral.com, and he's Cyberlaw on Twitter, the one and only.
You.
So thank you so much. And Xeni, it has been a delight. Thank you so much for joining us.
Hey, likewise.
Any final thoughts?
Yeah, so first, I'm just noticing as I scan Twitter that the documents in the Gizmodo Apple iPhone leak case were unsealed by the San Mateo court judge, and I haven't read them yet. I wasn't that distracted during the call, but I'm going to go read Declan McCullough's early report on CNET, and I think everybody's continuing to follow that case with interest. But also, since everybody else mentioned books, I just reached behind me and grabbed a book that I'm planning to read over the weekend by Joseph Menn, Fatal System Error, which promises to be the hunt for the new crime lords who are bringing down the internet. The back of the jacket says Richard Clark, also a cybercrime book author. Fatal System Error accurately reveals the secretive global cyber cartels and their hidden multi-billion-dollar business, proving cybercrime does pay and pay well. I remember swapping emails with Joseph over the past couple of years as he was off to these trips to Russia and former Soviet Union states that he wouldn't tell me anything about. And all of that is finally here in the book. The cover looks really cool, and I can't wait to read it. Yeah, he's a serious investigative reporter who's done some amazing righteous work in the past, and I just can't wait to get through it.
Wonderful. Thank you for that. I'm going to put that one on my bedside table as well. That doesn't mean it's going to get read, but we'll join.
I have a big stack next to my bed, too.
Yes. We'll join the others in limbo there. And, of course, people can find Xeni at boingboing.net. And does Boing Boing Video have its own address where they can subscribe and see your show?
Yeah, thanks for asking. All of the recent episodes are also featured on boingboing.net, but you can go to boingboingvideo.com or YouTube/Boing Boing Video.
Wonderful. And she is Xeni Jardin on Twitter. And if you're going to make a T-shirt out of her tweets, please be in touch beforehand.
No TGI Fridays gift certificates for me anymore, people. I want rubles, okay?
Wonderful. Thank you so much, all of you. And thanks to all the listeners and viewers for tuning in to TWiL 60. We'll be back with you next week, live at Friday, 11 a.m. Pacific time. Take care.